All right. Good morning, everybody. Thank you so much for joining and welcome to today's webinar. I'm Jenna Witherby with 401k Plan Professionals, and I'm very glad you're here. We have a timely topic to cover today: Minnesota's paid family and medical leave program and important employment law updates. Our goal today is to walk you through what's changing, what you need to know, and how to prepare. We'll keep things to about 30 minutes for the presentation and try to leave some time for questions at the end. If you have time to stay longer than 30 minutes, if there's more Q&A, then feel free. But if you need to drop at 10:30, that's completely fine. With that, let's jump in and get started. And again, my name is Jenna Witherby. I'm one of the advisors on the team at 401k Plan Professionals, and today's presentation is a part of our monthly webinar series. And so typically we'll take about 30 minutes or less, and we don't just talk about 401k. So we get into, broader topics having to do with someone's financial life, or from an employer standpoint, other benefits and things that may be top of mind for you. A recorded link from this webinar will be going out afterwards. Feel free to rewatch it, share it with others that may find value in it. And all of our webinars are recorded and they're posted on our website, 401k Plan Professionals, and on our YouTube channel as well. So we have two lovely speakers with us today. So Genevieve Frazier is with Maguire Agency, and she is just kind of our go-to person when it comes to anything benefits. And Maguire Agency, in the employee benefits department, they're responsible for minimizing your employee benefit costs while maximizing your benefits. And so they're very consultative. They're experts at what they do. And I'm just really grateful that Genevieve is here to share her knowledge on this topic. I know she's been doing a lot of presentations on Paid Family Medical Leave Act lately. And then Evon Spangler is with us from Spangler de Stefano. And their role is assisting business owners with issues affecting both their business and their family. And as her role in a counselor of law, she assists clients in understanding their goals and providing them with knowledge to implement their goals. And I'm just so grateful that both of these women are here today to, again, share their knowledge on this topic and answer some of the questions that you have on this timely topic. So I will hand it over to you both, and thank you so much. I'll watch the questions in the chat.
Awesome. Well, thank you very much. Really looking forward to discussing this topic with you guys. I know this is a hot topic for a lot of employers. So what we're going to talk about today. So this is a very short webinar. Usually these webinars last us just a little bit longer than the 30 minutes. So if you have questions as we're going here, certainly pop them in the chat and Jenna can stop me and ask the question. I know that there's a lot of questions that are still out there with employers. So today's agenda is I am going to talk through the paid family medical leave. So what you need to know and do now, or hopefully have already done, an employment law update. So Yvonne's going to take that one on with the PFML versus ESST, and then the employment handbook. So again, what you need to know and what you need to do now. So I'm going to start this presentation with pieces of this law are still fluctuating. So I am going to give you the most up-to-date knowledge, but I want you to know that there are still questions out there. So if you have a question that has not been addressed yet, you might not be alone. But we'll try to get some of them answered for you guys here today. So paid family medical leave. So this is coming about January 1st of 2026, and this is for all employers of all sizes. So if you're an employer in the state of Minnesota, you are required to participate in this new law. The way that it's going to work is you're going to start paying into the program as of January 1st. So you're going to pay January, February, March, and those premiums are then going to be due in April. All employees in the state of Minnesota and all employers in the state of Minnesota are covered by this new law. So covered employment. So an employee's entire employment during the calendar year is considered part of this. 50% or more of their time needs to be spent in the state of Minnesota to be covered under this law. to be an eligible employee. So after 90 days of employment is when they're eligible to participate in this program. This does not include independent contractors, federal employees, self-employed individuals, and designated seasonal hospitality workers. Now, there was a question that was submitted prior to the webinar. I'm going to read that here because that can be addressed on this slide. So is an employee able to use these benefits beginning January 1st, or do they need to be paying into the program for 90 days? So if they're a current employee of yours right now, they are eligible to start their benefit as of January 1st. That 90 days that's referred to on this slide here, that 90 days is for new employees. So as of January 1st, these benefits become live and active. Exceptions to an eligible employee. So independent contractors. So an independent contractor, there's a very strict definition with the state of Minnesota on if that person is to be included or not. If you have a specific question surrounding an independent contractor, should they be working for your organization, I'm going to recommend that you reach out either to your insurance broker who can help with that question or reach out to the state of Minnesota directly. Payroll tax. So how we're going to fund this thing. So originally, when this law was first passed, it started at a 0.7. That has since ticked up to a 0.88. Now, there is stipulations in the law that depending on claims in 2026, that 0.88 could go up to a 1.1 in 2027. So next calendar year. So a payroll tax for a small employer is 0.44. So you're going to pay half of that and the employee can pay half of that. You could pay more, so you could pay 100%, but 0.44 is the most an employee could pay towards this plan. And the way that the employee is paid is it's a math problem. It's a percent of their wages. So depending on which bucket they would fall into, it's a percent of their wages. And the way that that's determined is using the state average weekly wage. And in 2025, it was $14.81. So I already mentioned this, but the rate may be split equally between the employer and the employee at that 0.44. The maximum premium, so I get this question a lot, how much is this going to cost? So the maximum premium that would be paid is $29.80 per week, but keep in mind that 50-50 split, it would be $14.90. Employer $14.90, employee $14.90. So alternative plans for paid family medical leave. So what else could you do? So I'm sure that you are all familiar with this, but you can get an insurance carrier plan that would, you could purchase outside of the state plan, or a self-insured plan. So there was one question that was submitted on self-insured plans. I'm going to read that question to you here. So I'm interested in this. This is the question. I'm interested in a self-funded option, but I have not found resources or referrals for creating a plan document or TPAs for this. I asked your broker and a benefits company who I've worked with to no avail. How are others becoming self-funded? So since this law is so new, there's no template that anybody has that could be followed to just copy and paste to have a true self-funded plan. My recommendation to you would be to work with an ERISA attorney. So the ERISA attorneys are able to work with you and work through to be sure that you have the correct document in place. So document is step one. And then you're also required to purchase what's called a surety bond. And a surety bond can be purchased through a bonding company. So my thought is, since you've already reached out to the various TPAs, that's probably why they don't have a coined document already that can be supplied. Okay. Why choose a private plan? So we get this question a lot. So there is a cost difference between the state plan and a private plan. So if you are a small employer, meaning you have 30 employees or less, the state actually has a subsidy available should you qualify for it. There is a calculator on their website that you can use to determine if your specific company would be eligible for a subsidy through the state. That would bring that 0.88 to a 0.66. Okay, but you're still, do the 50-50 on that, right? Like we already talked about. So then why would I do a private plan? Well, we have a standalone carrier that is offering groups in that smaller space, if you qualify for it, a rate of 0.59. So you could still get a private plan outside of the state, and it would still be less expensive. In addition, so why you choose a private plan, you could just tack it onto your ancillary benefits. So that's really what we are in a flurry of doing right now. So your ancillary benefits are going to be like your principal and your Mutual of Omaha and your Unum and those folks, right? You could reach out to them and say, hey, what would it cost to add paid family medical leave onto our ancillary benefits? The other thing that many people are concerned about is the administration of claims. So once this thing goes out, right, who's going to be the best go-to market for the actual administration when an employee has a claim to answer questions? You know, do you want those to run through the state or do you want it to run through a private carrier? Private carriers are going to have a ton of experience in this instance, right? Because paid family medical leave is not a new concept. There's 13 states in the United States that already have paid family medical leave in place. So many of these carriers have a ton of experience in already administering these claims. On top of that, it's nice to have all of your pieces with one company: short-term disability, long-term disability, paid family medical leave, and allowing them all to integrate together. Coordination of benefits, that was my next one. W-2 and FICA tax service. So these, in addition, can be added to the private plan carrier cost. So who do you want to hand out the W-2 at the end of the year if they go out on claim? And then who is paying that FICA tax service for you? Do you want to be doing it as the employer, or the carrier could do that for you as well? There's a small rate for them to do that. Most of my groups have chosen to do the carrier route. Just as a heads up, if you do decide to opt out, the state is charging a cost to do that of either $250, $500, or $1,000, depending on your group size. So there's an opt-out cost to be out of the state plan. The opt-out period ends November 10th. So that date has moved up. Now, we have some carriers saying that their drop dead dates, even to submit paperwork, was September 15th. So we know that that carrier is out. However, moving forward, a lot of the carriers have now told us October 15th. So you still have a few weeks if you haven't done a private quote yet, where you could submit and get a private quote option going. If you do not opt out, you are automatically opted in to the state plan. Okay, so reporting for paid family medical leave. So what's this going to look like? So starting in December, you must notify your employees about the program. So the paid leave program will provide language. So there's two pieces that you're required to provide. One piece is out and the other piece is not. So the piece that is out is just that one-page brochure that you'll put up like with your minimum wage brochures. The second piece that is not out is all of that language that needs to be provided to the employee: what carrier you're with, what your policy number is, how they submit a claim. And what we're doing for our groups is that's going to be a part of that compliance kit that we put together. That includes your WIC and your CHIP and all of those notices. We're going to include that as a part of that kit. The language for that is not out yet. As of Tuesday, I did not check yesterday. Then starting in January, employees must include the employee earnings on that wage deduction. So if you're, splitting it 50-50 starting your January payroll, you have to include it. And then April 30th, employers must submit the premium payment for the plan. Okay, so this is the state average weekly wage. So it's a progression scale. So lower income earners earn a higher percent of wages, and the percent of income will decrease as the workers earn more. So a good question that we get here is, how would the employee then get 100% of their earnings? So there would be no instance where the employee would make more than 100% of their earnings. But what you could do is stack your short-term disability on top of paid family medical leave and perhaps move that short-term disability to voluntary. So the employee would be paying 100% of that. And then those two products can work in tandems to make the employee at that 100% level if your organization chooses to do that. If the wage is more than 100% of that state average weekly wage of the $14.81, the employer receives 55%. Regardless of the employee's earnings, the max weekly benefit they received is capped at that $14.81. Reinstatement is very important as well. Employees are entitled to their job back after completing their leave if they've been in that position for that 90 days. And that's why that 90-day window is very important. So what are we paying for? So employees are eligible to receive 12 weeks of paid leave for their own serious health condition or pregnancy, and up to an additional 12 weeks of paid leave to care for a newborn, adopted child, safety leave, care for a family member who has a serious health condition, and that leave is capped at 20 weeks in a single benefit year. An employer may require leave to be taken under this chapter to run concurrently with leave taken for the same purpose under the Minnesota Parental Leave Act. You cannot compel an employee to exhaust sick, vacation, or personal time while taking the leave. So the filing of claims, so it must be based on a single qualifying event of at least 7 days. The days must be consecutive or could be intermittent leave for bonding, leave for parents, things like that. And the 7-day qualifying event is retroactively, sorry about that, payable period. And it's not an unpaid waiting period. So they will retroactively go back and pay for those 7 days. So filing of claims, an applicant is ineligible for family or medical leave benefits for any portion of a typical work week that occurs before the effective date, fails or refuses to provide information for which the applicant is paid to work for. I'm going to answer the safety question here just in a moment. Or has received unemployment benefits. An employee may use vacation, sick, or paid time off. They can take effect on a Sunday of a calendar work week, and an applicant that's incapacitated or failed to timely apply through no fault of their own can request retroactive leave. So the definition is quite broad. So a family member includes, so this is who they could take the leave for: spouse, child, parent, sibling, grandchild, grandparent, son-in-law, daughter-in-law, or an individual who has a relationship with the applicant that creates an expectation and reliance on the applicant. So that's the one where it's very broad definition of a family member. There was a question on safety leave. So safety leave is due to a domestic abuse, sexual assault, or stalking of the applicant family member that they need leave for. So medical attention, services from victim service organizations, psychological or counseling, relocation, or legal advice or legal action. Serious health condition, inpatient care, hospice, residential, medical facility, period of incapacity of 7 days or more is what that one would qualify for. And a serious health condition kind of continued here: incapacity due to pregnancy, bed rest, period of incapacity for chronic health condition that requires a periodic healthcare visit. The last slide here before I turn it over to Evon is the anti-retaliation and anti-interference. So as an employer, you must not discharge, discipline, penalize, interfere, threaten, restrain, anything, right? An employer must not obstruct or impede an applicant for leave or benefits or exercise any of the other rights under the PFML. So the employee is protected, is what that's saying. All right. Oh, I got it done. That was very fast. I'm going to turn it over to Evon.
Thank you, Genevieve.
Yeah.
So I am talking about the comparison of earned sick and safe time and paid leave to start off with. And here is a slide that shows you the difference between earned sick and safe time and paid leave. The key to remember is that these programs are separate programs and you have to follow the requirements of each of the separate programs. So moving on to the next slide, we have changes to ESST that happened during 2025. The first one is that if the need to use ESST is unforeseeable, the employer can require the employee to give a notice that is, quote, reasonably required by the employer, end quote. And that changes the language that was in the previous statute that said as soon as practicable. The next change that was made during the session is that now an employee is not prohibited from voluntarily seeking or trading shifts with a replacement worker to cover the hours the employee uses as ESST. This language was added to the prohibition, which still exists, that an employer may not require an employee to seek or find a replacement worker to cover the hours the employee uses ESST. So now the employee can voluntarily do that. The next change is a change to the documentation requirement. Now, if an employee uses ESST for more than 2 consecutive days, the employer can require reasonable documentation. Previously, it was 3 consecutive scheduled work days. Now that was changed down to 2 in 2025 legislature. The final change to ESST during the last legislative session is that now an employer is permitted to advance ESST to an employee. And if the advanced amount is less than the amount the employee would have accrued based on the actual hours worked, then the employer has to provide additional earned sick and safe time to make up the difference. But that provision doesn't come into play until January 1st of 2026. With respect to employee handbooks, what you need to know and what you need to do now. First of all, it's really important that you're reviewing your time off policies and figuring out whether or not you want them to be revised. So the thing is that when you're looking at PTO time, for example, versus the paid leave, are you going to make adjustments to that? How are you going to allow certain benefits to continue, such as short-term disability, for example? And if you are you going to allow that to stack on it so that the employee during their time off can receive 100% of a wage replacement rather than what is allowed under the paid leave? So it's really important that you're looking at all of those policies and making certain that you have them set up so that employees are receiving the amount that you actually want them to receive. And I've seen employers across the board. Some of them are stacking to the maximum amount. Some of them are taking away certain benefits because they believe that paid leave is equivalent of the benefits that they had before. So it's just really important to make certain, because if your policies aren't changed that you have in your employee handbook, chances are very high that you could be allowing employees to take time off and be paid for it in a manner in which you actually aren't comfortable doing. And also, I just once again want to reiterate, you cannot delete, amend, modify, change anything in ESST that the law requires. Again, that is a separate program that is separate from their paid leave program, and you have to follow both of the programs to the fullest extent as required by law. You can, as was discussed before, require that the paid leave runs concurrently with leave taken under the Minnesota Parental Leave Act and also the Federal Family and Medical Leave Act. And just as a reminder, FMLA is applicable to those who are 50 employees or more, unless you have decided to opt into that program through your employee handbook. One of the things to be thinking about when you're reviewing your handbook and how you're going to stack any sort of benefits or not stack them is one of the things to determine is whether or not you are going to allow for front loading ESST for 80 hours, if that's something that you do. You also want to make sure that your employee handbook, since you're going in and making revisions anyway, has all of the mandatory requirements of the law that's in the employee handbook. So in Minnesota, if you decide to have an employee handbook, which is not required by law to have one, but if you do have an employee handbook, the law requires that certain policies are included in that handbook. So now this would be the time to make sure that your employee handbook is compliant with the current laws. And that's all I have.
All right. Thank you so much, ladies. Okay, so we did have one question coming in about what would qualify as safety leave. Do you want to explain that one, Genevieve?
Sure. I thought I did that. So what would qualify for a safety leave? I pulled this slide back up. So it's domestic abuse, sexual assault, stalking, of the applicant or their family member, provided the leave is to do the following things listed here. So seek medical attention, obtain services from a victim service organization, obtain psychological or other counseling, relocation due to the abuse, or seek legal advice or legal action. Does that answer the question?
Yeah, definitely. What other questions do you have? Does PFML allow for intermittent leave?
Yes, it does. That was addressed up here too. I'm so sorry. I know I had to speak very quickly. But yes, it does allow for intermittent leave. Um, and yet, so I always use the example with my groups of, like, let's say you need to take every Friday off to care for an aging parent. You can do that. That waiting period would still exist, and then it would retroactively go back and pay for that intermittent leave.
All right. Do all size employers have to do PFMLA only through the
Yes.
state plan?
Yep, we get that question all of the time. It's not, I know when the state has passed laws in the past, it's been, oh, if your group is, 10 people or more, but nope, it is 100%. All employers of all sizes have to do PFML.
And what percentage, just a guess, would you say you're seeing go with the state plan versus a private plan?
Um, what we run into a lot is groups that just don't qualify for a private plan are going with the state plan. So groups that have a really high female population are ending up on the state plan, just baby bearing years, right? Or groups with a lot of turnover are going with a state plan. So I would say if anybody is even close to, getting out of the state plan, they're 100% going with a private plan. I've even had groups pay more to go with a private plan versus going with the state plan.
Hmm. It just kind of depends. Okay, we had another question coming in.
Yep.
Members of an LLC receive K-1, not W-2. Are members eligible / required to participate in paid leave?
I would believe, I'm almost 100% sure, but I would ask you to look at the FAQ on the state website just to confirm. But I believe K-1s are not included. It's W-2 earnings. And remember, it's tied to your unemployment account with the state. So anytime you're filing unemployment for those folks, that's really what it's tied to. But I know that the FAQ on the state website does address that for K-1 earnings.
Another one, how do you prove that an employee is actually taking FMLA for legit reasons and not just taking personal paid time off?
Oh, we get this question all of the time. So there is supposed to be a form on the state website, and that form has not been published yet. I would, in my mind, the way I think of it as when they go out like on short-term disability leave, and there's the form that they have to get from their doctor, right? And they have to fill it out and submit the claim. I would imagine it would look similar to that, but to my knowledge, that has not been published yet.
Okay. And another one came in kind of similar. Can an employer require proof of the need for any Minnesota paid leave, such as for safety reasons?
I believe Yvonne, do you know the answer to that? I mean, it would be.
If it's under the Paid Family Leave Act, then you can. So if you're under ESST, then it depends.
Okay. Is it required for the employer to track the PFML leave taken for each employee, or is it tracked through the state or the private plan?
So what will happen is you're going to have a portal, whoever you're with, right? Private or state or whomever. And that portal should allow you to track claims, but it is on the employer to track the claim. There's not yet any software to my knowledge that's doing the tracking for you.
And then someone asked, will the slide deck be sent out along with the recording? The deck won't automatically go out with the recording, but Genevieve, Evon, if people request this deck, are you okay with me sending it to them?
Absolutely.
Okay,
That's fine.
thank you. All right, any other questions? All right, well, we're right at 10:30. Thank you so much, everybody, for joining us this morning. Yvonne, Genevieve, you are both amazing. You covered a lot of material in a short amount of time, and we understand that there will be some changes and fluidity with this program, but thank you for getting us timely information. And this recording will be out not only sent to you automatically as an attendee, but it'll also be on demand on our website and our YouTube channel, as well as all of our other previous webinars. So you can see so far in 2025 the topics that we have covered. This QR would take you right there. And then I think we have one more slide. Looking ahead, we have in November, I'll be covering our 8 Steps to Financial Wellness series, and we have a newly created worksheet that goes along with those educational videos. So that'll be a great one, and that's for plan sponsors and participants, so can certainly send that out to your staff. And then in January, we'll kick off the year with our typical retirement planning considerations and market update. We've already have webinars planned through April. There's a few that are specifically for plan sponsors I just wanted to highlight. So in October, I'll be doing part 3 of 3 on our fiduciary training, so strategic fiduciary oversight for 401k plans. And then in February, we'll be kind of starting over with that series. And in May, we're going to be doing a deep dive on plan design trends and do some case studies there. Okay, so again, thank you so much, Genevieve, Yvonne, attendees. We really appreciate your time today. So certainly feel free to reach out to myself or any of my team members if you have any questions. And we look forward to talking with you soon and bringing you more content on our future webinars. Thanks, everybody. Okay, bye-bye.